Welcome everyone to our webinar today. Don't let divorces wreck your finances. This is Jim Allen. I am the Director of Financial Planning and a partner at Anchor Bay Capital. I'm also a certified financial planner and a certified divorce financial analyst, and I'll be your presenter for today. So today we're going to focus on divorce and your finances. At Anchor Bay Capital, we specialize in transition planning. For most people, that's transitioning into retirement, but we also work very closely with people who have had a death in the family and it's transitioning to widowhood or helping with estate settlement. But we also have specific expertise in transitioning due to divorce, and that's our topic today. And so we're going to talk about a lot of different things. We're going to focus on the divorce process and all your options for getting divorced these days. We'll also talk a little bit about the phenomenon of silver divorce, how baby boomers are getting divorced at a much higher rate than any other age group. And then we'll get into kind of the nuts and bolts of the divorce process, things like spousal support or alimony and child support, and then the process for breaking up your assets. We'll talk about some of the tax issues, and then we'll kind of talk about some common mistakes to avoid, things that we see that can cause problems for you. Then starting over once you're divorced, how to get your finances back in place and start over. And finally, we'll talk about how a financial neutral, which is the role we typically play in a divorce, can help you in the process. And then finally, we'll open it up to any questions you may have at the very end. So let's start with the modern divorce process. In the old days, not that long ago, you had what we call the typical approach, meaning litigation. So each spouse would get an attorney, and then they would duke it out, and ideally they would come to some kind of marital settlement agreement. And if not, then they had to go to court. And we'll talk about the pros and cons of that approach. But today you have a lot more options than you used to. You have what's typically being called alternate dispute resolution. And so we'll talk about those. The pro se or do-it-yourself divorce, how to use mediation, or how to use the collaborative divorce process. We'll go into a little bit of detail about each of those. So we'll kind of start with the simplest and easiest is the technical term is a pro se divorce, meaning you don't have attorneys involved. As the do-it-yourself divorce. And this is pretty common. Actually, about half of divorces do not use an attorney. And honestly, they really only work for, maybe it's a very short-term marriage and there's not a lot of assets and, there's no acrimony. And so if it's uncontested, it's like, hey, this didn't work out. We're just going to go our separate ways. The do-it-yourself divorce can work. One of the benefits, obviously, is it doesn't cost you as much. You still have to have the court filings, as we'll talk about. And then you can pay a service to help you file those documents and prepare them, or you can just do it yourself with like the divorce in a box that's shown here. And, when you don't bring an attorney into the process, it usually can ease the tension between the spouses. And a lot of times that makes the divorce process easier. But there's some issues with the do-it-yourself divorce. One is there's no discovery or recourse. So if you've got one of the spouses who's hiding income or assets, do-it-yourself divorce isn't going to uncover that. And the same as there's no recourse if you come to an agreement and you find out afterwards that there's missed or hidden assets. It's hard to go back and undo the settlement agreement. A lot of times too is when you're doing it yourself, things like the tax consequences of splitting assets, or for example, separating a pension, which you do via something called a qualified domestic relations order, quadro. You don't know how to do those things yourself. And without the expertise of either the attorney or a financial neutral or something like that, those kind of things can get missed. But if it's just a very simple, hey, we're going to part ways, we're not splitting up any assets, the do-it-yourself divorce is certainly the easiest, fastest, and most cost-effective way to get divorced. And next is the old-fashioned way, or litigated divorce. So in this situation, each spouse has an attorney, and the attorneys are the advocate for their client. And so attorneys have been trained to take that advocacy role very seriously. And that's why things get kind of nasty and contested sometimes, because each attorney is going to do the absolute most possible for their client, and the attorney on the other side is going to do the same. And so that's how it can become kind of a hotly contested battle. Ideally, you come up with a settlement negotiation between the two attorneys, and a settlement agreement is reached. Or if a settlement agreement can't be reached, then it goes to court, and the judge makes the decision about how everything's going to be split up. Now, this is certainly the most adversarial of systems, and because of that, it's the highest cost, because the attorneys are constantly meeting with each other and arguing points and trying to outdo each other. And so a cost of a typical divorce in California where you're using attorneys can easily be $30,000 to $50,000 plus. The benefits are you have that discovery process, you're getting legal advice, and you do have someone as your advocate and trying to negotiate the best possible settlement for you. So yes, there are costs associated with a litigated divorce, but you also have the benefit of having someone in your corner helping you get the best agreement. Now, if you go to court because attorneys can't come to a fair settlement, then everybody's losing control, and it's a judge who decides who's going to get what and how much spousal support is going to be, and child support and all those kind of things. So you can come to an agreement outside of court using attorneys, and that's usually the case. But if it's really a nasty divorce and it's become very contested and adversarial, then going to court may be your only option. And that's typically what you're going to see in the most ugliest of divorces. So it's going to cost you a lot of money, and you're going to lose control over the process because the judge is ultimately going to decide how this marriage gets split up. So that brings us to kind of the alternate resolution types of divorces that are going on today. And these are pretty new phenomenons. They've only been around for a few years. And we'll talk about collaborative divorce first. What you have with a collaborative divorce is there is a team of people who are all working together to help the two spouses come to a settlement agreement. So it's a non-adversarial approach. The team is working in the best interest of everybody involved. So each team, each spouse will have an attorney as part of the team, but it's a little bit different role. The attorney is not there as the advocate per se and trying to out-negotiate the other attorney. They're just there as the advocate and to provide guidance for each spouse. You typically have a coach who is going to kind of keep the process on track and keep everybody in neutral and keep it from becoming adversarial. And then you have a financial neutral, which is the role I typically would play or our firm would play, is where we would be evaluating all the potential financial options and providing that information to the team and to the spouses so that then we can determine which financial option is the best overall and helps meet the goals of everybody. And then if there are children involved, you may have a therapist or a child specialist who serves as the advocate for the child. So when it comes to custody and visitation and all of that, you've got someone who's looking for the best interest of the children. And then you have the attorneys who are looking for the best interest of each client. And then you have the coach and the financial neutral, who are just, the coach is keeping everything moving along. And the financial neutral is just providing all the financial options, providing input and information. And then the team with the two clients negotiates a potential settlement, and hopefully everybody comes to an agreement. So collaborative divorce is designed to be non-adversarial, which means that if each client's going to have their attorney, and if it starts getting sharky and everybody's going to start at being adversarial and arguing, and the whole collaborative process falls apart, the entire team has to withdraw from the process. And so in that situation, it's in the best interest of everybody to not get adversarial and to keep the process moving along and be collaborative. Because if something happens and now it's going to go to litigation, everybody's out of the process. The clients have to start all over with new attorneys, so you've got increased costs. So it's not in the best interest to have this process be adversarial. The team has advocates for both spouses. The team has an advocate for the children. You've got the financial neutral who's looking to come up with the settlement options. And as I mentioned, the coast keeps it moving forward. Now, you would think that the cost would be potentially higher because now you've got a bunch of people involved in the process rather than just the two attorneys. And the process is higher than mediation, which is the option we're going to talk about next, but it is lower than litigation. And depending on the team makeup, whether you need a child specialist or whether you need a coach or two or the financial neutral or whatever, it's probably in the range of $15,000 to $30,000 to do a collaborative divorce instead of the $30,000 to $50,000 that was going to cost you with a litigated divorce. And in this case, the spouses are retaining control over the whole process. They're not putting it into the hands of the judge or the court. They're going to come to a settlement, and collaborative divorce can be a great way to go, as long as it's not too ugly between the two spouses. So this isn't necessarily the ideal situation if it's going to be very adversarial, but also it doesn't have to be where it's totally, everybody gets along great and all of that either. It's totally amicable, because you have the advocates for each side, and people that are doing collaborative divorce as members of the team, they've been specifically trained in this process. And so they know how to keep the process moving along and come to a fair settlement for everybody involved. And then the next type of alternative dispute resolution is mediation. And so what you have here is the spouses are going to jointly determine the outcome. And so they're going to use the mediation process, and they're going to have a mediator who helps them come to an agreement about what the settlement's going to look like. But mediation is non-binding and it's voluntary. So it's not like arbitration where a separate third party is making the decisions. For example, if it goes to court, the judge makes the decisions. With this, the mediator is not helping them or not making the decisions for them. They're neutral and they don't make any decisions. Their role is to just help them come to a resolution that fits with everybody. So they're not giving legal advice. They're going to help the clients understand each person's position and the issues, and then help them come to an agreement. The clients may or may not have an attorney on the side. Sometimes a mediator is an attorney. Sometimes they're not. Sometimes it's just someone who's trained in mediation. And you still have to have an attorney to draft the settlement agreement. So once the mediator helped you come to resolution on a settlement, then someone still has to draft a settlement agreement. It's got to be filed and all of that. Sometimes the mediator takes that role as an attorney. Sometimes they have an attorney they work with who drafts the agreement. This is certainly lower cost than either litigation or collaboration. Typically, it's in the $5,000 to $10,000 per spouse. But this one isn't effective without the participation of both parties. So mediation is not going to work unless the relationship's fairly amicable. Both parties are willing to sit at the table and hash things out and let the mediator do their job. So if it's adversarial on one side, then mediation's not going to work for you. So collaborative divorce may still work, or ultimately it may have to go to litigation. And again, a financial neutral may be used in mediation like it is for collaborative divorce. You kind of look through all of the financial issues and help the spouses understand their options and the situation. And so again, the financial neutral is not making any decisions. The clients make the decisions, but the mediator and the financial neutral are just providing all the information and helping the clients come to some kind of resolution. We kind of look at it as a spectrum from, the best relationship between the two spouses to the nastiest relationship, and then also from the lowest cost to the highest cost. If you've got a great relationship, like I said, the pro se or do-it-yourself divorce may work. That's certainly the lowest cost. Next is if the relationship's good, mediation might be a great way to go, and it's certainly lower cost than the other options. Kind of in the middle is the collaborative divorce, because you have a team. It's still, it's got to be somewhat amicable, and both sides have to be willing to collaborate. But if they can, the team can get them through the process at a lower cost and more quickly than going through the litigation route. And finally, you get into the litigation, where typically the relationship's not great, and either maybe one person doesn't want to get divorced, or one of them who wants the divorce is hiding assets or income, and then you need the help of an attorney to uncover all that and litigate that. And then finally, if even the attorneys can't come to settlement, then it's going to go to court. The judge is going to decide. Obviously, that's the highest cost, and that's typically the worst relationship. So that's the option available to them. Okay, and so kind of the next topic I want to talk about is senior or silver divorce. This is certainly a growing phenomenon in my practice. I would say the vast majority of the clients I've been working with in divorce issues over the past several years have been baby boomers, people that are nearing retirement or they're retired. The rate of silver divorce has doubled in the last 20 years, where all of the divorce in all the other age groups has actually declined. So this is the only age group that's growing. And, there's a bunch of reasons for it. One is increased longevity. You think about it, before, someone who's maybe 65, they were maybe only going to live 5 to 10 more years. And they figure, at this point, I'm just going to stick this out. And then, some of it too was, maybe the wife didn't work, was a homemaker or something like that. And so it was just going to be too difficult to start over at that late age. But nowadays, maybe retirement's going to be 25 to 30 years instead of 5 to 10. And a lot of spouses have worked, and they have their own financial situation. And so it's easier for people to do this nowadays. It's also more accepted than it was with previous generations. But when you have a silver divorce, you've got more complex financial issues. Typically, this generation has the most assets. They've saved over, 20 or 30-year marriage. And so there's more assets to divide. There's increased income needs because now, maybe both people aren't going to be working. And so how do we provide the income that both of them need once they're divorced? You have issues like Social Security benefits and things like that. And then not working increases the difficulty in recovery, because when you divorce, there's always going to be, setbacks for people. They're not going to have the same income levels. Their assets are going to be decreased. They may be paying spousal support, things like that. And it can be compounded by someone who's not working or is going to not be working pretty soon. It just makes recovering from a divorce a little more difficult. And that's why a lot of silver divorces use a financial divorce professional to help them navigate that and come up with an asset division and income divisions that are going to help both people have a fairly comfortable retirement. So let's talk about the divorce process. And so we're kind of focused on California here, but the rules are pretty similar just about everywhere. So most states are now what are called no-fault divorces. In the old days, you couldn't get divorced unless there was a reason, like physical or mental abuse or adultery or something like that. Nowadays, you can just say, hey, it's not working out. We're going to go our separate ways, and divorce is no fault. The vast majority of states have a no-fault divorce system. So the process is the same regardless of the form of divorce you're going to use. You still have to file the divorce or separation documents with the court. So typically one spouse is going to file and petition for divorce. And again, maybe they're using an attorney to do that, or maybe it's do it yourself. So even if it's do it yourself and both of the spouses are working together on this, you're still going to have someone file and be the petitioner, and then the other person's going to be served and has to respond to the divorce. Then you're going to provide the financial information, and that information, the income, expenses, the assets, all of that, that's used for child support purposes, for spousal support or alimony purposes. So you've got to fill out all the financial documents. Once you've started the document process, then you're either going to come to an agreement, either through mediation or collaborative divorce or through your attorney, and you come up with a marital settlement agreement, which is going to stipulate who's getting what, how much spousal support is going to be paid, if any, how the child support is going to be paid, custody, visitation, all of that kind of stuff. That can't be, an agreement can't be met, and it can't be negotiated, and the parties go to trial, and then a divorce judge is going to make the decisions on all of these things, and then the divorce will be become final. And it takes 6 months and 1 day after the respondent, the person who didn't file, is the respondent, the person who received the divorce papers. 6 months and 1 day after that person is served, the divorce can become final in California. So that's the process. And like I said, it really doesn't matter whether you're using mediation, collaborative divorce, an attorney. The process is pretty similar. It's just who's going to be doing these things in terms of filing the forms and all of that. Okay, so kind of the first two big issues in a divorce are child and spousal support. And they work differently. They serve two different purposes. So child support is formula-based, meaning that each state has their guidelines. So they're going to look at the income and the assets of each spouse, and then they're going to base whether child support is payable and how much based on the income and the visitation or custody rights of a particular spouse. So typically, the spouse that has primary custody is going to get child support. And the level is based on this formula. We pretty much input all these income numbers into this formula, and the numbers are spit out, and they're met with. It can be negotiated or modified, usually not down, but they can be negotiated where more is payable, things like that. And child support's paid until age 18. So once the child hits age 18, child support's no longer payable for that child, and it stops. So in terms of taxation, child support payments are not taxable to the people who are receiving it, and they're not deductible by the person paying it. So that's child support. Like I said, it's pretty cut and dried. It's all based on formulas. You input the information, and we use a program called Family Law, and it kind of spits out the numbers. Then you have spousal support or alimony. It's typically called spousal support in California, but it's the exact same thing as alimony. And this is subjective. It's going to be based on the needs of each spouse, the ability of a spouse to pay it to the other spouse, and things that come into play are how long was the marriage? I mean, longer term marriages are going to probably get a higher level of spousal support, and also for a longer period of time. It's also going to be based on trying to maintain the lifestyle of the spouse that's going to receive spousal support. And things that come into play are like the age, the health, how long are they expected to live? So how long does it need to be paid? And things like employment. Do both spouses work? What is the income level of one spouse versus the other? And then things like if one spouse doesn't work, what did they do in the past? Did they have career skills that could be used? For example, maybe one of the spouses was a teacher, and then they decided to stay at home and raise the kids. They could go back to work as a teacher. They have skills, and so that may shorten the length of time that spousal support will be paid. So there's a lot of factors that go into spousal support. It's not formula-based like child support is. In terms of the tax treatment, these rules just changed essentially last year. Before 2019, if you paid alimony, you got to deduct the alimony payments, and the spouse who received it was taxed on it. But for any divorces after 2019, it's taxed differently. The spouse who pays it doesn't get it deducted, and the spouse who receives it doesn't get it taxed, isn't taxed. So now it looks much more like child support in terms of the tax treatment. So those are kind of the first two things we have to look at is child support and then spousal support or alimony if any is going to be paid. And then after that, we have to look at the assets and how do we split up the marital estate in terms of assets. And so in California, this is a community property state, which typically means that each spouse is entitled to half of the assets compiled during the marriage. So that's the kind of the starting point. So whatever you've accumulated during your marriage, you're each entitled to half of it. And that can be changed via negotiation, but that's kind of the starting point. If you have separate property, which is assets you either brought into the marriage before and you've kept them separate, or if maybe you received an inheritance, as long as you've kept those separate from the community property, you get to hang on to those, and they're not typically part of the negotiation. So what you'd be dividing up would be the community property. Issues we run into is, tracing back separate property. If something separate property that was brought into the marriage hasn't remained separate property, and we have to go back and look and make sure that it's still separate property. And then things like pensions, maybe you worked someplace and you worked there for several years and built up pension benefits and then got married. Well, part of that pension will be community property, part of that will be separate property. So we have to do tracing to figure out the percentages that are separate, the percentages that are community. So determining what separate property and community property is kind of the starting point, and that can be complicated. It again depends on how long you're married and whether you've commingled things or you've kept them separate or whatever you've done. So in terms of the common assets divide, usually the biggest is the home, and there's a lot of decisions that get made around the family home. And this is one of those areas that can be kind of contested. Are we just going to sell the home and split the proceeds, and each will get their share of the proceeds? Does one of them really want to keep the house? And that's pretty common. One wants to stay in the house. And if that's the case, it's like, okay, when does the other person move out? And then we have to look at, okay, if you're going to keep our $750,000 house, then what am I going to get to replace that? Is it going to be other assets or personal property, or are you going to essentially refinance the house and then buy me out? So we have to look at a lot of the options there in terms of how does one person keep the house and still get the other person the assets they're entitled to in the settlement. So that you have to look at things like refinancing the mortgage. If we're going to sell it, when are we going to sell it? There's tax consequences that we'll talk about. So there are a lot of issues around the family home. And the family home's one of those assets that typically not only are there financial implications, there's usually personal implications as well. One of them may be totally connected to that house and not want to give it up, where the other person could care less. They would just want to get the cash. So the family home is usually the biggest asset, and it's one that can be the most complicated. Then you have your retirement plans, your IRAs, your 401ks, your pensions. And these, again, they could be split depending on the community property, et cetera. But this is a little more complicated. If you have a qualified retirement plan, like a pension or like a 401k, there's a process called a qualified domestic relations order that is used to split that asset up. And that's got to be done, and it's got to be done properly. And this is an area that gets fouled up. Or if it's an IRA, then the IRA doesn't require a quadro. It can just be split, and you'll do a spousal rollover. Again, it's got to be done right. We got to make sure that the money gets transferred to the IRA of the other spouse without it being treated as a distribution, which would be taxable. Then you have your investments in your bank accounts. That have to be split up. A lot of times that's fairly straightforward. Maybe one of the spouses just sets up a new account, and withdrawals or distributions are made and transferred to the new accounts for the divorced spouse. And finally, you have your personal property, and this is another area that gets kind of contested. I listed pets there, and we've seen plenty of issues surrounding who's going to have custody or visitation of pets. So that can become a major sticking point. But then you have things like the jewelry or the cars or the boats or any of those kind of things that have to be negotiated. Who's going to get what of the personal property, or is it going to be all be sold and the cash proceeds split up? So these are the things that get negotiated and determine who's going to get what assets, and we need to evaluate the consequences of splitting up these assets, because not all assets are created equal from a tax standpoint. And so just talk briefly about the tax issues in divorce. So the first thing is, okay, once we're getting divorced or we are divorced, what's our filing status? So while you're married, in most cases you're married filing jointly. And that's the most advantageous from a tax standpoint. But if you're in the process of getting divorced, one of the spouses has moved out, you may use married filing separately. And the way it's supposed to work in a community property state is you each pay tax on half of the income and half of the deductible expenses. That can be worked around. If there's situations where maybe one spouse is making all the money, the other spouse isn't making much money, that's not a fair way to do it. So we can do it differently from a tax standpoint. But while you're married, those are your options. You're either going to file jointly, and you're considered married if on December 31st, you don't have a formal decree of divorce or a formal separation agreement. Or if you have a separation agreement but you're still living in the house, you're still married. So after you get divorced, then your filing status is either going to be single or it's going to be head of household. The difference is head of household, you're single, you're divorced, but you have dependents, typically children. So in that case, you get special additional exemptions in terms of the standard deduction, things like that. So while you're married, it's either married filing jointly or married filing separately. Once you're divorced, and again, you're divorced if you're not married at the end of the year, you're single or head of household. In terms of splitting the assets up, this is where I talked about making sure it gets done properly. In most assets, the tax basis carries over, meaning there's no tax consequences to splitting the assets up. So let's say that you have a $1 million home that you paid $500,000 for. If you split the home and one person keeps it, then there's no tax consequences to splitting the home. The same with a qualified retirement plan. If we split it properly, meaning we use that qualified domestic relations order, or we do an IRA rollover, there's no tax consequences to doing that. And if we are selling the home, one of the things a married couple has is a $500,000 exclusion on the capital gains, as long as they've lived in the house for 2 out of 5 years. If you're single, it's $250,000, but obviously we're talking about married couples here. So if they sell the house related to the divorce, then they still get to use that $500,000 exclusion. So they sell it, there are tax consequences versus transferring the house to one of the spouses, but you would have the $500,000 exclusion. So we have to factor any tax consequences into the settlement agreement in terms of transferring assets. So some common divorce mistakes we see. Probably the biggest, and again, this is more common when we're dealing with a pro se divorce or something like that, is not uncovering all the income and assets. Um, it's sad to say, but there are plenty of situations where one spouse knows they're going to request a divorce and they start hiding assets and changing title to things, or things like that. And so we need to find all that out. It's supposed to be disclosed on the financial documents that get filed, but they aren't always. And so, one of the roles I have when working with a client on these divorces, I'm typically looking at the tax returns for the last couple of years, and I can pretty quickly see where, last year you had, $5,000 of interest, which equates to, maybe a several $100,000 bank account. But on the financial document, they only stated that there's a $10,000 bank account. Well, a $10,000 bank account's not going to generate $5,000 of interest. So what happened to the account that was generating this interest? Or the same thing, if there were dividends that were paid from mutual funds, where did those mutual funds go? And then we're looking at business income. That's one of those things. If someone's self-employed, it's pretty easy to manipulate that. And a lot of people will do it for tax reasons, but if we're looking at the true value of that, we need to do some of this forensic accounting. We also may need to do tracing to determine whether it's community property or separate property. So making sure we know about all of the income and all of the assets is very important. And the next one is not all assets are created equal. And the example here typically is, hey, I'll take the family home and you take the IRA. If they're, say, equal value. Well, guess what? If I get the family home and then I sell it down the road, A, I get capital gains treatment, and B, I've got that $250,000 capital gains exclusion, where you take the IRA, that's all ordinary income. And so a $1 million IRA after tax is really only worth $700,000, or a $1 million home after tax may be worth $1 million or slightly less. And so we have to look at, what is being offered in the settlement. Is it really fair? And what's the true value of that asset? So, not considering the tax implications of, the asset division is a huge mistake. And then the next one, I've mentioned this a couple times, is incorrectly dividing assets. If you don't do it right, you're going to create tax problems for yourself. And, if you're under 59 and a half, you could also be creating, the additional 10% penalty. So when you have qualified retirement plans, doing the quadro properly and working with someone who knows how to do these things is critical. The next big mistake we see is, okay, you got divorced, but then you don't complete the process. You don't go out and close the joint credit card, or you don't refinance the mortgage, or update your beneficiaries on life insurance, all those kind of things. So there's a whole post-marriage checklist that we go through to make sure that the loops are getting closed and everything is getting done. And finally, probably one of the bigger mistakes is choosing the wrong divorce process. I've seen several cases over the last few years where, hey, we started with mediation, but then going into it, you can tell pretty quickly one of the spouses has no interest in being amicable about this, and they're playing games and they're hiding assets. So now you just spent a bunch of money on a mediator, and then you've got to go out and get an attorney, and now you're really going to spend a bunch of money. So being realistic about the process going in, I think is pretty important. If you can get away with using mediation or collaborative divorce, those are better options. You're going to come out with a fairer settlement, typically, one that you have control over, and typically at a lower cost. But they don't work for everybody. So kind of going into the divorce process with your eyes open and coming up with the solution that's going to be best for you is the way to go. At the same time, don't automatically just assume, hey, I've got to go get an attorney and we're going to duke this out, because the only winners in a divorce are the attorneys, because they're racking up bills. So if maybe you can get by with collaborative or mediation, it's going to save you a heck of a lot of headache and a heck of a lot of money. Okay, so then once you finally get divorced, you've got to start over. And sometimes this means, long-term marriages where maybe one spouse didn't work. It's you got to go out and establish your own financial identity. You've got to get credit built up. You've got to open new bank accounts, all of that kind of stuff. A lot of marriages these days, both spouses have worked and they both have their own financial identity, but not always. And again, there's still things you're going to have to do in terms of setting up your own retirement plans and all of that kind of stuff. You need to go and update your insurance policies. This is one of the big mistakes we see is you get divorced and say you've got a group term life insurance policy through work, but your ex-spouse is still the beneficiary. If something happens to you, that beneficiary designation controls, and your ex-spouse could get that money. So it's a common mistake we see. So you've got to make sure you go update all of your life insurance policies and things like that to make sure that the ex-spouse is taken off as a beneficiary. You're going to be facing new financial realities. You're probably going to have less in terms of assets. You're going to have less in terms of income. And so we've got to create a budget and figure out what realistically you can afford to spend with your new income, taking into account child support or spousal support and when that all ends and all of those kind of things. Just like your life insurance policies, you're going to need to go get new estate documents. You're going to need to have a new will and a new power of attorney and a healthcare power of attorney and a new living trust, all of those kind of things. So you're going to have to go and update all your estate documents. You're going to need to update all your employee benefits. Make sure that your ex-spouse is taken off your medical plan and all of those kind of things. And then big part of starting over is developing your own financial plan, figuring out, okay, this is what I have to work with now. This is what I have to live off of. What's this going to look like for me in retirement, particularly those silver divorces where we're dealing with, are you going to run out of money in retirement? So we've got to develop a whole new financial plan. And part of creating that financial plan is all of the other things. Updating your estate documents, updating your insurance policies, and your, creating your budget and all of that. And then unfortunately, a lot of times now starting over also means you're going to maybe lose relationships with friends and things like that. So can you maintain those relationships or are you going to have to develop new relationships? And so, divorce is all about loss. Not only are you're losing a spouse that you at one time loved and had a long-term relationship with, you may be losing the relationship you had with your in-laws or friends, all of those kind of things. So starting over is about the relationship aspects of it as much as it is about the financial aspects of divorce. And so then, what's the role of the financial neutral? Why am I giving you a presentation on divorce? It's because we serve a pretty important role in this whole process. So we work with maybe just one spouse to analyze that settlement agreement. So you're going through mediation, you're going through attorneys or whatever. We can take a look at that settlement agreement and look at things like, hey, you know what? He's getting a better deal because he's getting the house and you're getting, the short end of the stick because you're getting taxable assets like an IRA. So we can analyze that and maybe give you, better options. And then we do the things like the asset tracing and the forensic analysis. We're typically doing that with just one spouse. For the most part, is to help find those assets that may be hidden or forgotten about and figuring all that. There are also plenty of situations where we're working with both spouses. So maybe you're doing a pro se divorce, or we've got one of those we're working on right now where it's like, hey, we're amicable. We're going to try and do this ourselves. But what we really need some help with is figuring out who should get what in terms of the financial assets. And so we can help them look at all their options and help them come up with a fair settlement agreement. And then we do the same thing in mediation settings where maybe we're working with the mediator to analyze all the financial options, and then the mediator's still doing their thing by coming to a fair settlement agreement. We work as a financial neutral on a collaborative team. There's a couple of collaborative associations I work with where we're working as a financial neutral. We can just do things like a tax analysis for running some tax projections for you. We certainly assist with the asset transfers, making sure that, once the divorce settlement agreements come to, somebody's got to make sure that these investment accounts are split up properly and that the IRA is rolled over and that the quadro is done properly. So we work pretty heavily in the asset transfer. Then finally, once the divorce is over, we kind of switch roles and we go from the role of the financial neutral, where we're providing you this analysis and options, to now we work as your financial planner and helping you come up with that starting over and developing your financial plan for your new life. So when we're serving as a financial neutral, we're working on strictly a fee base for the work we're doing. So we typically quote those things. Sometimes it's hourly, sometimes it's a flat fee. But we'll quote you, this is what we think you need. This is about how many hours we think it's going to be. This would be the cost. Once the divorce is final, we take that hat off. And now we're working with you as your financial advisor. And we're advising you separately from the financial neutral role. And that's quoted typically as a financial planning fee or an investment management fee. But it's a separate different role. In both cases, we're acting as what's called a fiduciary, meaning our recommendations are based on your best interest, not ours. So there's no conflict of interest. Everything's fully disclosed. But that's the role of the financial neutral, and this is a role we serve with divorces. I mentioned with just one spouse, with both spouses, as part of a team with the mediator, collaborative divorce, and we also serve this role with attorneys. We have attorneys that we work with that we'll do the forensic analysis of the asset tracing or the asset transfers for the attorney, and typically the attorney is paying us and the attorney's billing you. That's usually not as cost effective as working with us directly, but in some cases that's the role that we play. So hopefully that's given you kind of an overview of what you're facing if you're contemplating divorce or you've just started divorce. As I mentioned, try and avoid all of those mistakes. Pick the divorce process that's going to work best for you. I would recommend that working with a financial neutral is a smart thing to do, because we can hash out a lot of this and keep it more amicable and give you all your options, and certainly at a lower cost than you're going to pay a divorce attorney to essentially either do those for you where they don't necessarily have the expertise, or to hire someone like myself to do it behind the scenes and then bill you. So at this point, I'll open up to any questions you may have. My contact information is there. So if you have questions after this presentation or you'd like to have a consultation, feel free to reach out to me either via phone or email. And I wish everybody a good evening, and we will talk to you soon.